maybe Eleni, we need to pin Sana and Annika.
Yes, I will do that now.
Ale, I see that most of people could connect properly now. So we have about 40 attendees. I think more are joining us as well. So good afternoon. Very happy to have many of you here with us to discuss quite an important topic, which is researcher mobility, and especially at international and pan-European level. For us, that's quite key. We have two experts with us this afternoon. First with Annika. Annika German is working at Fraunhofer, one of our largest member in Germany. She is HR and labor law head of the group who is looking at those issues in Fraunhofer, so at the Central of Fraunhofer in Munich. I hope you are well in Munich today, and if I don't say anything wrong, Annika.
Perfect.
Yeah, and we have Sana with us from Finland, and Sana is team leader global mobility at VTT, which is also one of our largest member located in Finland. So we have those two experts that will present you. As you know, we've done a position paper, and we wanted to kind of explain the issues we had and what we think some of the implementation of some of the regulations are not always handy, at least for us, our big employer of researchers in Europe. Annika, I think I let the floor to you. We will go through the presentation and then we will have some time for Q&A. You can use the chat function. I will monitor the chat, and after presentations, then I will play the moderator with the Q&A and the chat section. So, Annika, please, the floor is yours.
Thank you, Muriel, and thank you, EARTO, for having us today. Really, thank you very much in advance. Maybe just one technical aspect. We will record the meeting, but only the part of our presentation. And then we will have a second part with a Q&A session that will not be recorded. So then we can really get into the cases. So thank you for having me today. I just give you a very short overview here. We will have an introduction. Why does it matter at all? And then we will really dive deeper into the four biggest hurdles that we have found and that we think are really worth looking at and maybe doing some changes on them. This is the A1 forms, the EU notification requirements together with equal pay. We have the issue of remote work from abroad, and then last but not least, the recognition of residence permits for mobile researchers. So next, please. I would talk about why does it matter, just to give you maybe a short impression of why two so very enthusiastic Europeans like Sana and me really have big pain points here. As you all might know, we have an ongoing war for talent, and we have to cope with the shortage of skilled workers in Europe. And what we see here is that the hurdles we will talk about later are really a big obstacle in this regard. They hinder international research and mobility and also innovation in Europe. Sana will dive deeper into this on the next slide. And in our view, this causes huge administrative efforts, and all of this without a meaningful added value. So we cannot really feel the sense of it, and it really causes high costs. So these are our main pain points. And now we want to explain to you why we think it really matters and it's worth looking at it. And we, of course, hope that with this webinar, we will at least find some more followers on our way to the amendment of some rules. So I give the word to you, Sana.
Thank you, Annika. And next slide. Thank you. So basically, as we all know, one of the key objectives for the Union is to strengthen the scientific and technological base by creating an research area which researchers, scientific knowledge, and the technology can move freely. And this one is further explored on one of the key articles of the Treaty on the Function of the European Union, Article 179. And the Article 179 reflects and specifies the characteristics of the field of research and the researchers working on it. Further, the objectives mentioned on the treaty are then confirmed and elaborated in the European Charter for Researchers. And what I would like to highlight is that almost 700 organizations, and here a significant number of RTOs, have implemented a human resources strategy for researchers and also signed the Codex for Recruitment recommendations on recruitment of researchers. Even more than that, many of us have received the EU logo of HR Excellence in Research. And as we understand that the aim for EU is strengthen the European research area, we wanted to highlight these factors which hinder our possibilities to send researchers cross-border and work against the both Horizon Europe programs and national funding, which support then the mobility. Next slide, please.
I think what Sanna told us now is somehow also the crucial point here, and why it hurts so much to have formalities and bureaucracy that is really a burden. I would like to go a little bit into the first pain point. It's the A1 forms for business trips and secondments here. The legal background, of course, might be interesting for you, is an EU regulation on coordination of social security systems. It's a well-known regulation, I think, and it's also quite old. It was basically in the beginning aimed to protect workers who were sent from one EU country to another, and especially in I would say, typical industries like slaughter, building, or transport. And of course, I think the original aim was really a good one. What is the A1 form? What happens here? So before each business trip or before each secondment, the so-called A1 form must be issued by a local authority. It's the employer who applies for the A1 form. And as an example, in Germany, the employer has to apply for it at the health insurance of the employee, which then in general issues confirms, so to say, the social security in the home country. Now, what happens if the employer does not apply for this A1 form, or if the employee travels without having the confirmation with him or her? What we saw are cases where the employee was denied access to the premises of a company, of maybe the partner project company, or on a trade fair. What we also saw were cases where, for example, the health insurance of the employee refused to reimburse the costs of a medical treatment abroad just because there was no A1 form. In rare cases, maybe even there could be employee penalties, or this could also have unfavorable effects on immigration or entry permits. So it is something. Now, what hurts a lot for us as an RTO is that it's quite a lot of effort to apply for this A1 form. So the HR person really needs around about 20 to 30 minutes to apply it, to fill out the papers and to send them away. So yeah, in our view, this is really something that is too much. Next, please. So what is needed in our view to improve the situation? We would say that the EU regulation should be amended. So we propose that staff participating in short duration business trips should be exempted from this need to apply for an A1 form, at least if it's a business trip below 14 working days, so only a short one, and especially for business trips like participations in consortium meetings, workshops, or conferences. Additionally, we would propose that there is a clarification made, which means that business trips in general are not considered as postings. So that would make it really easy. So we go to the next, and I give the word again back to Sanna.
Excellent.
Oh, I'm sorry, it's my slide. I think I was confused a little bit. The next is even also mine. It's the second obstacle that we want to explain to you. It's really something that hurts a lot, actually, in my opinion. The EU notification requirements. The legal basis we have written here on the slide. You can find it. It's the Posting of Workers Directives. And what is this now? A notification is required if an RTO or any other company sends a person also on a business trip or a secondment abroad. It is like you have to tell the other country, the authorities in the other country, that be aware that we are sending a person to your country. The problem actually is that there are no uniform standards as to when a business trip really is a posting and has to be notified or not. There is no centralized information hub. So neither the European Labour Authority, it's a quite new European ministry, or not ministry, but an authority, nor EURES have any centralized information on how does it work in each EU country. So what does it mean then in practice? For example, if we send people to France, in many cases, we need to provide them with the employment contract in French language. We sometimes even need to have a person, kind of a representative in the company or in the organization, who is able to speak fluently French and to answer the questions of the authority. There are countries where you need to make the notification already 8 days in advance, and if you don't, you get in trouble with the authorities. And so this not a standard. There's no uniform deadline for when the notification has to be made. This really causes a lot of effort, because in every case you have to check, is this a posting? Do I have to notify it? And then when do I have to do it, and how, and in which language? That means that in many cases, or in many RTOs, we use service providers, and we have the experience that it costs around about 250 up to even 1,000 euros per case, depending, of course, on the country and the scope of registration requirements. But this is really a lot of money. The risk that we are facing if we don't follow this notification requirement is maybe high administrative fines of up to 50,000 euros. And what also could happen is that we have an entry ban, so that our organization cannot even enter the country anymore. Yeah, I give over to Sanna for some examples.
Thank you. So basically, these are just small number of examples what we collected with Annika for your reference to give different kinds of ideas how the countries have implemented these regulations nationally. And it's by no means a comprehensive list, but it's just a bit of food for thought here. And we know that the EU Commission didn't intend the legislation to cause these kind of cases, but at the moment it's the situation where we live in. And obviously the greater purpose, like Annika said at the beginning, is to protect the workers and ensure everything is done on a correct way. So we would like to start with the example from Belgium. So Belgium is actually one of those countries which we think is a good example of the national implementation of the declaration process. The declaration process itself has been already in force in Belgium since spring 2007. And there are several exclusions on the national law where the notification doesn't need to be made, which are especially favorable and actually also suitable for our researchers, because most of our researchers move the countries as part of the EU-funded projects, nationally funded, publicly funded projects, but very rarely on a customer cases where a fee would be charged. So, for example, in Belgium, they have excluded short, small circle meetings from the notification when the meetings are less than 60 days per year per an employee, and the duration of visit to such a meeting is less than 20 successive days. Belgium has also recognized scientists as important group because they have been excluded from the registration requirement when they participate into a scientific program at the host university or the scientific institution when the visit is under 3 months. And we see that this is a great example of simple implementation and working implementation. Like Annika mentioned, I don't go too much into details regarding the France because we partly covered it, but part of the French notification, the problem also arises on the fact that we cannot use representatives in France, which means that the consultants cannot be used as a contact for the online notification. And this means that in cases where we send multiple employees simultaneously to France, that we would need to enable one of the employees access other employees' data, which is not something what is very GDPR compliant and not something what we like to do. And also, at least for VTT, many of our employees traveling to France don't speak French. So that kind of limits our possibilities also who we can use as a contact. In Italy, actually, our third example, the notification needs to be made in Italian. The online system works very well, but what is actually good in Italy, even the researchers aren't exempted from the registration requirement. We can use at least the help of consultants to submit the documentation. In Italy, there are similar requirements to France that certain key documents need to be issued in the local language, and this can also increase the cost. And obviously, many of our language capabilities doesn't cover all the European languages that we could actually check whether the translation was correct, which is provided by the experts on the translation agency. In Sweden, our fourth and final example, the posting notification has been made really simple for the employers to complete. But the options, unfortunately, because the local law doesn't specify researchers as a specific group, the options on the online system doesn't work for us. So when we actually report the posting as a RTO, we're most likely using an incorrect option in the system because we are not providing services in Sweden, but our employees are taking part meetings or participating to a short jointly funded project work which takes place in Sweden. And these are just some of the examples what we wanted to highlight with you, which hinder our possibilities to send our employees abroad and also increase the cost for the organization when sending their employees to another country within the EU area. Next slide, please. And here, Annika did already cover in a short form the penalties, which are in relation to the non-compliance. And this is actually something what we both have seen in the one of the consultants' seminars and thought it was a good way of sharing with you all how the different countries have categorized the kind of the cost of non-compliance, so the penalty fees. Also highlight that there are some countries where, for example, in Norway, something are still very unclear and not well specified, so which causes additional burden for the organization sending to employees on these countries. And like Annika mentioned, there are other possible sanctions beside the penalty fees. And actually looking these 3 sanctions listed here, the penalty fees start to be the smallest of our issues maybe on this if we are not compliant with the legislation. So these sanctions include blacklisting and reputation damage, criminal prosecution, and also travel bans and visa restrictions. So some of these are related directly to the organization, but some also to our employees, and we would like to avoid any situation where our business trips cause travel ban for our employee to a certain country. Next slide, please.
So in addition to these notification requirements, there is the so-called equal pay principle that came only a few years ago within the Posting of Workers Directive. And it says that in case of long-term secondments, which are, for example, especially when we have a Marie Sklodowska-Curie project, then the terms and the conditions of employment of the host member state, so the state where the employee goes to, must be granted to the posted workers from the first day. This makes all this even more complicated because then it means that, for example, if we have a Marie Curie project and we want to send, or we even have to send somebody abroad for example, 4 or 6 months, then we have to check in advance what are the maximum work or the minimum rest periods. We have to check what is the minimum paid annual leave, the remuneration, including overtime rates. We have to check what is the usual working condition situation for this kind of job in the host country. And then if there's something different from what the employee has now, we have to make a new agreement, and we have to really make sure that these rules from the host countries are fulfilled. The problems that we face here are, it's a little bit always the same, but I just want to mention it. In all the cases, we need an external service provider. And this means huge costs. We have had cases, and that both VTT and Fraunhofer, we have really had actual cases where the examination costed more than 10,000 euros for one single case. And the thing is, in the event of a non-compliance, so if this was in any way checked and found out, then we also would face fines here. So again, I just want to remember on the connection that we started with. The EU defines and supports mobility. That's really fine. But the success of realization is really in question here. If then, for example, an institute, that's what we've seen already, decides not to apply for an EU-funded project just because they know that the costs will be too high. Next slide, please. What is needed here? It's also, I will go through this very quickly because the next topic is much more interesting. We would propose also here an amendment of the EU regulations. So a complete elimination of EU notification requirements actually for the whole research sector. So no notification requirements, and ideally not having to keep to the equal pay principle. If this is not possible, because of course we always think with a plan B on the side, then we would say that there are minimum requirements that we would like to propose. And they are, if a project is for public benefit, and this is, for example, within Horizon Europe or within a national program, then at least researchers should be exempted from these necessities. Then a uniform, standardized framework condition should really be implemented throughout the EU, so that not every country can have a separate regulation and separate rules. and a centrally retrievable information in the key European languages would really be crucial here. Maybe the European Labour Authority could be a point for this, I don't know. But these would really be our minimum requirements to improve the situation in this regard. I hand over back to Sanna with the next slide.
And now I got the pleasure of getting the topic of which is been very hot recently from the HR perspective as well, which is the international remote work and also our capabilities to hire the best talent for the European area. And as we know, the remote work increased and kind of started on almost every organization when the pandemic started. And the organizations are now in a situation where we need to reimagine the work models what we have for our employees. And even more importantly, this has created an expectation from the employee's point of view that you can work from anywhere, because it has worked in many cases so well working remotely from your home. So the expectation is there and it's there to stay. And the remote work is no longer considered anymore as a temporary emergency measure, which we used at the height of the pandemic. But as we face the talent shortage, we need to find a way to allow the cross-border remote work as well in the future. And also the flexibility, what it brings in the recruitment, and also where we can have our employees based. And also, this is important not just only for the attraction purposes, but also to retain the key talents within the European research area who have been hired by the different organizations here in Europe. And the organizations now, from my perspective at least, we face a kind of situation where we need to develop a remote work policies, which many organizations are keen to do. But at the moment, due to the regulation which is in place and which is in partly quite old and not suited to the current situation, there is a high risk for the organizations to allow employees to work remotely on a cross-border. So for example, the point 2 on the slide, we wanted to highlight the fact that the regular activity in another EU member state might create a permanent establishment for the organization. And this is true according to the advice what we've received and how we read the tax laws as well, that even individual employee could create this on the worst case. What therefore the international remote requires from the organization is quite a complex checkup for the matters what needs to be checked before the remote work can be allowed. And in many cases, I think our line managers and management are willing to let our employees to work cross-border, but it's quite challenging with the labor law, immigration law, tax law, social security and payroll reporting and accounting considerations to allow long-term remote work abroad at the moment. And this is only EU area which we're talking here now. So it comes really much more complex when we go outside of EU and we need to start to consider further topics as well, which at least to us include export control, IT security, GDPR, to mention a few additional topics which needs to be checked. And obviously as an employer, because all of us want to be responsible employers to attract and retain the talent, is to ensure the safety of the employees in each country, and the regulation around this one, especially outside of Europe, can be very varied between the countries. And also the fourth and final point is that the lack of uniform basic conditions within the pan-European area means that we need to check each case individually before going ahead or allowing new country to be implemented within the organization as a allowed country for the international remote work. Next slide. So what is needed is basically how we see that what is needed to support the attraction and retention of the talent is the extension of the regulation regarding the social security system. And we propose that the employer's country of domicile should be always the applied while the employee works temporarily on another EU member state. Also, maybe not something what EU can just self change, but there is a need for update on the international tax law and double tax treaties. How, for example, the OECD Model Tax Treaty Article 5 is interpreted on the permanent establishment matter, and also basically how the researchers are considered on the cross-border situation under the tax treaties. So one example we can see is that some of the older tax treaties still have researcher exceptions there, which work really well on supporting the researcher mobility. But as the OECD Model Tax Treaty does not have researchers there anymore as one of the example articles, hardly any of the new tax treaties have this one. And this causes additional tax burden both for employees and the organizations regarding reporting. Even the taxation would remain on the home country of the employee. Next slide, please.
Yeah, I'm waiting for the next slide. It's coming, I think. Because last but not least, we have one, maybe only a small mosaic stone, but it is also an important issue. So the next slide, is it coming? Yeah, thank you. It is our last one, actually. So we're already almost finished with our presentation. We wanted to highlight the missing recognition of residence permits for mobile researchers throughout Europe. Here also the legal basis is a directive. It's the directive on the conditions of entry and residence of third country nationals. So especially for the purpose of research. And there it said that the countries should really have a regulation saying that if a researcher already has a residence permit in one country, and then, for example, is seconded on a long or short time assignment to another EU country, then the residence permit is still valid. What we see in practice is that this person has to apply again in the country he or she is sent to for a new corresponding permit. And this, of course, causes long waiting times at the embassies. This causes administrative efforts and sometimes even costs. And of course, it hinders in a way also to hire talent or to send them really within their programs abroad as fast as we would need them to. So what is our proposal? We call the EU member states here to implement the agreed procedure of the directive, of course, and to recognize a relevant residence permit issued by another member state. This would really be great. So I'm coming to the end, and thank you for listening up to here. I hope that you all have your questions, and we will now start into the questions and answering sector, so to say, as soon as we finish the recording. Thank you.